Right now, somewhere in America, a family is sitting inside a bank branch. They have a death certificate in hand, and a will their parent paid $800 to have drafted. They are expecting to walk out with the money. Instead, the branch manager tells them something that will destroy the next 20 months of their lives. He tells them the money is frozen, not because the account is empty, not because of fraud, not because anyone made a mistake, because nobody told their parent about 4 free pieces of paper. 4 pieces of paper that every single FDIC-insured bank in this country is required to provide, if you ask. Almost nobody asks, because almost nobody knows they exist. The bank is not freezing the account out of malice. The bank is following the law. When someone dies without naming a beneficiary directly on the account contract, the money cannot transfer automatically. It goes to the probate court. And here's the part that surprises almost everyone. Your will is not a beneficiary designation. Your trust is not a beneficiary designation. The conversation you had with your children about what you want does not count at a teller window. The only thing that matters is what is written on the bank account contract itself. If a valid beneficiary is on file, the money passes directly. If there is no beneficiary on file, the account goes through probate. And probate is not quick. And probate is not cheap. According to Trust and Will's national survey of 1,000 Americans, the average probate case takes 20 months to close. 20 months. According to the American Bar Association, the process costs between 3 and 7% of the total gross estate value. On a $500,000 estate, that is $15,000 to $35,000, consumed by court fees, attorney percentages, publication notices, executor bonds, administrative costs, all paid before your family sees a single dollar. 56% of Americans believe probate costs less than $1,000. Only 4% know it can exceed $10,000. Most people learn what probate actually costs after the vault is already sealed and the attorney is already billing. My name is Kevin. I am not your attorney. I spent the last several weeks reviewing federal banking regulations under 12 CFR Part 330, State Probate Code Variations, FDIC account transfer rules, and court filing data across major states. Here is what I found. The bank is not hiding anything. The bank is not breaking any law. The bank is doing exactly what the contract on your account requires. The problem is, nobody explained what that contract says before you signed it, and nobody at the bank is required to explain it until it is already too late. The 4 forms in this video are all free. They require no attorney. Each one takes about 15 minutes to complete. Together they build a wall around every account your family will need to access in the worst moment of their lives. And they work on accounts your existing will and trust cannot touch. By the end of this video, you will know exactly which form goes on which account, why each form is a completely separate legal document, and the 5 specific mistakes that destroy even a properly filed form after the fact. Let me start with the one everybody has heard of, but almost nobody has actually confirmed is on their account. The first form is the Payable on Death designation. The banking industry also calls it a POD form, or a beneficiary designation form. In older legal language, dating back to a 1904 New York court decision called Matter of Totten, it is called a Totten trust. Different names at different banks, same form. Same legal effect. Here is exactly what it does. When you file a POD designation on a bank account, you are creating a private contract between yourself and your bank. That contract activates the second you die. Your named beneficiary walks into the branch. They present a certified death certificate. They show identification. The bank processes the transfer. No judge, no attorney, no notice published in the local newspaper, no waiting period, no filing fee, no executor bond. The contract executes automatically. The legal foundation is FDIC regulations under 12 CFR Part 330. Under those regulations, a properly filed POD designation supersedes your will. It supersedes any trust document. It supersedes any verbal instruction you gave your children about that account. The bank reads the contract on file. The contract controls. Not the will, not the trust, not the conversation. Now I want to stop here, because this is the point where most people push back. They say, my attorney drafted a will. My will covers everything. I am good. This is the most expensive misunderstanding in American personal finance. And I want to be direct about it. Your will does not bypass probate. Your will guarantees probate. A will is a letter of instruction directed at a probate judge. The judge must receive it, validate it, publish a notice to creditors, wait for claims, inventory the estate. and release the assets after all of that is complete. A bank teller cannot execute a will. A bank teller executes a bank contract. The POD form is a bank contract. The will is not. That is the entire difference between 48 hours and 20 months. Walk into your bank today and ask the teller for the payable on death beneficiary designation form. They are required to provide it. Bring this information written on a piece of paper. The full legal name of every person you want to receive the funds, their date of birth, their current address, and their social security number. The bank needs the social security number to verify identity when the claim is made. Without it, the payout can be delayed. When you fill out the form, name your primary beneficiaries and assign percentages. If you have 2 children and you want them to share equally, you name them both at 50% each. Then name a contingent beneficiary for each primary. The contingent is the person who steps into the slot if your primary beneficiary dies before you do. Without a contingent, if your primary beneficiary predeceases you and you never update the form, that account reverts to your estate and goes directly into probate, all of it. Let me tell you about Patricia. She is 73 and lives in Tennessee. Her husband Leonard passed away in 2023 after 41 years of marriage. Leonard had a savings account at a regional bank in Nashville. He opened it in 1987, the year before he married Patricia, back when he was still married to his first wife, Carol. Leonard and Carol divorced in 1991. Leonard hired an attorney and updated his will completely. The attorney drafted a new document that removed Carol as a beneficiary and named Patricia and their 2 children instead. Leonard paid $1,200 for the new will. He put it in a fireproof box. He told Patricia everything was handled. What Leonard never did was walk into the bank branch and ask for the POD designation form. Nobody at the bank told him the form existed when he opened the account in 1987. Nobody mentioned it when he changed addresses. Nobody mentioned it during the divorce. The account sat for 32 years, with Carol's name still on the beneficiary card. When Leonard died, Patricia presented the death certificate at the bank. The teller looked at the screen. The screen showed Carol as the primary beneficiary, no contingent. Within 48 hours of presenting her own death certificate, Carol collected $64,000. Patricia received nothing from that account. The attorney she consulted told her the POD designation would hold up in court. The case was essentially closed. This is not unusual. This is one of the most common estate planning failures in American banking. The POD form is a private contract. The will is a court document. The private contract executes before the court document is ever opened. Review your POD designations every 3 years at minimum. After a divorce, update them the same week the papers are signed. After a spouse or primary beneficiary passes away, update them before the month is out. The outdated form will beat your current will every single time, regardless of what you intended. Before I move to the second form, I need to stop and address the single most common reaction people have when they first hear about the POD designation. They think of a simpler solution. They decide to add their child's name directly onto the account as a joint owner. I understand why this feels logical. If your child is already on the account, they can help manage bills while you are alive. They can access everything the day you die without needing a separate form. It sounds like one step that solves 2 problems at once. It creates one very large problem instead. When you add a child to your bank account as a joint owner, the law treats that money as equally theirs right now, not eventually. Not after you die. The moment their name appears on the account, their legal ownership begins. Full ownership, same as yours. Here is what that means in practice. If your child is involved in a serious car accident and someone sues them for $200,000, the plaintiff's attorney can file a levy against your bank account. Not your child's separate account, your account, because your child is a legal co-owner. Your retirement savings can be seized to satisfy a judgment against your child before you are even aware there is a lawsuit. If your child goes through a divorce, their spouse's attorney can argue in court that your bank account is a marital asset. Your savings becomes evidence in someone else's divorce proceeding. If your child owes back taxes, the IRS has statutory authority to levy any account bearing the delinquent taxpayer's name, including an account they share with you. The POD form prevents all of this. A POD beneficiary has 0 legal ownership of the account while you are alive. 0. Their creditors cannot touch it. Their divorce attorney cannot claim it. The IRS cannot levy it to satisfy your child's debt. The designation is completely dormant to the legal system until the exact moment you die and the contract executes. You get the same outcome at death. Your child receives the account. but every dollar in that account remains fully protected from their life circumstances while you are alive. Do not add your children to your checking account as joint owners. Add their names to the POD form instead. That one distinction can be the difference between your retirement savings surviving your lifetime intact and your retirement savings disappearing into your child's legal problems before you are gone. If this is the first time you are hearing that your will has no authority at a bank teller window, and that adding your child to your account as a joint owner exposes your savings to their creditors right now, hit subscribe. This is what we do on this channel. We find the rules that cost families everything, and we put them in writing, before someone has to learn them inside a courtroom. The second form is the one nobody in finance content covers, because it solves a problem most people do not know exists, until they are standing at the bank with a key in their hand, and the manager will not let them open the box. The safe deposit box. The metal container you rent from the bank. It holds your will, your deed, your stock certificates, your birth certificate, your mother's jewelry, every critical document your family needs to navigate your estate. Here is what most people do not know. When the bank learns of your death, federal banking regulations require them to seal your safe deposit box immediately, not eventually, not after a grace period, immediately upon notification. Your child can have a copy of the key. They can have been paying the annual rental fee for years. The bank manager will not allow entry. And here is the circular nightmare. To open a probate case, you need the will. To get the will, you need to open the safe deposit box. To open the sealed safe deposit box, you need a court order. To get the court order, you need the will. Round and round. While the funeral director waits. While the attorney starts billing. While the mandatory creditor publication period runs in the local newspaper. The form that eliminates this entirely is called a safe deposit box joint renter authorization. Different banks call it different things. Joint co-renter designation, joint access agreement. But the function is the same. It is a one-page contract amendment. It adds another person to your box rental agreement as a co-renter. A co-renter can access the box independently at any time, including immediately after your death, because the rental contract is legally theirs too. This form is completely free. It is filed directly with the bank, stored permanently on your box rental record. The person you add does not need to be present for every visit after they sign. They just need to come in once, sign the rental agreement, and their access is permanent. Walk into your branch. Tell the teller you want to add a co-renter to your safe deposit box agreement. Bring the person you want to add with you. Have them sign the contract. From that day forward, they can access your box independently, with their own key or with identification. When you are gone, they walk in, present identification, and open the box. No court, no petition, no circular waiting. New Jersey made this point in vivid terms. The state began matching death records against open safe deposit box registrations and sending agents to claim unclaimed boxes. One family described discovering their parents' box was hours from being seized by the state before they could get a court order to enter it themselves. The co-renter form would have made that race unnecessary. I do not know your exact bank or your exact state, but if you email me at kevinexplainsofficial@gmail.com, I will personally review your account setup against all 4 forms and tell you exactly which ones are missing. Small fee. Most save 10 times what they pay. The Quiet Rules is the guide I built after watching families hit this exact wall. It has the state-specific POD rules, the safe deposit co-renter request script, the contingent beneficiary language, and the full 4-form checklist to bring to your bank so nothing gets missed. $27 at kevinexplains.shop. If it does not save your family at least $1,000, I will refund it personally. The third form is the one that surprises most seniors, because it applies to accounts people assume they already covered when they filled out the POD at the bank. Investment accounts, brokerage accounts, stock portfolios, mutual fund accounts held through investment firms. These do not use a POD designation. They use a separate legal form, called a transfer on death registration, commonly called a TOD. The mechanism is legally identical to the POD. A named beneficiary presents the death certificate, identity is verified, and the assets transfer directly without probate. But the form is different from the POD. It lives at a separate institution, and it requires separate filing. Most seniors who have completed a POD at their bank have never confirmed the TOD designation on their brokerage account, because the bank never mentioned the investment account uses a different form. According to a 2026 estate planning report, fewer than 1 in 3 Americans with investment accounts have a current TOD designation on file. 2 out of 3 investment accounts in this country will go through probate when the owner dies. Your bank account may transfer in 48 hours. Your brokerage account holding the identical balance may take 20 months. Same family, same estate, two completely different timelines, because two different forms were required at two different institutions. The process for filing the TOD is the same as the POD. Contact your investment firm or brokerage. Ask for the Transfer on Death Beneficiary Registration Form. Provide the full legal name, date of birth, address, and social security number for each beneficiary. Assign percentages. Name primary and contingent beneficiaries. Sign the form. Confirm receipt in writing. Now let me address something that came up in virtually every estate planning comment section I reviewed. People believe that their IRA already has a beneficiary designation, and therefore their retirement accounts are handled. They are partially right, and dangerously incomplete. Your IRA has a beneficiary designation form. Your brokerage account has a TOD form. These are not the same document. They do not live in the same place. They require completely separate updates. Let me tell you about Earl. He is 77 and lives in Florida. He has 3 accounts: a checking account at his local bank, with a POD form naming his son Arthur as the primary beneficiary, a brokerage account at an investment firm with a TOD form filed in 2009, also naming Arthur, and a traditional IRA at the same investment firm with a beneficiary designation form he filed in 2002, naming his wife Norma as primary beneficiary. Norma passed away in 2018. Earl updated his will immediately. He called his bank and updated the POD. He called the investment firm and updated the TOD on the brokerage account. He believed he had handled everything. He never called about the IRA beneficiary designation, because when he updated the TOD, the representative did not mention they were 2 separate forms on 2 separate tracking systems. Even though both accounts were at the same firm, when Earl passes away, Arthur will inherit the checking account within 48 hours and the brokerage account within days. The IRA will attempt to pay Norma. Norma is deceased. No contingent beneficiary was named on the IRA form when it was filed in 2002. Because the primary predeceased the account holder and no contingent exists, the IRA falls into the estate and proceeds through probate. The same IRA that was specifically designed to pass outside of probate, with a beneficiary designation. All because 2 forms at the same institution were tracked on separate systems, and the representative updating one never confirmed the other. Call your IRA custodian separately from your brokerage representative. Ask specifically for the current primary and contingent beneficiary on file for every retirement account. Write down the names. If any name belongs to a deceased person, or if any contingent field is blank, request the updated designation form the same day. If this channel is the first place that told you your IRA and your brokerage account use completely separate beneficiary forms, even at the same institution, hit subscribe. This is what we do every week. We cover what the institutions leave out of the conversation you have with them. Now, I want to give you 2 specific rules about retirement account beneficiary forms that do not apply to the POD or the TOD, because these rules trap people even when they file everything correctly. The first is the spousal consent rule. Under the Federal Employee Retirement Income Security Act, commonly called ERISA, federal law requires that on most employer-sponsored retirement accounts, including 401ks and pension plans, your surviving spouse is automatically the primary beneficiary, unless your spouse has signed a notarized consent form agreeing to waive that right. This is a federal rule, not a bank policy. If you want to leave a 401k to your children instead of your spouse must sign a notarized waiver. If that waiver does not exist, the plan pays the spouse, regardless of what your beneficiary form says, regardless of what your will says. The second is the minor child problem. If you name a minor child as the sole beneficiary on any retirement account, the institution cannot legally distribute funds to a 12-year-old. The money will be held while the court appoints a legal guardian to manage it, which requires exactly the kind of court involvement the form was designed to prevent. The solution is to name a custodian under the Uniform Transfers to Minors Act on the beneficiary form itself. The form has a specific field for this. The custodian manages the funds until the child reaches the age your state sets, usually 18 or 21, and the process happens outside of court entirely. Now, I want to stay on inherited IRAs for one more point, because most beneficiaries discover this rule at the worst possible moment, usually during tax season, when the bill is already calculated and due. Under the original rules, a non-spouse who inherited an IRA could stretch distributions across their own lifetime, keeping most of the money growing tax-deferred for decades. The Secure Act eliminated that strategy for most non-spouse beneficiaries. Under the current rules modified by Secure 2.0, a non-spouse beneficiary must withdraw the entire inherited IRA balance within 10 years of the original owner's death. The account must be fully emptied by December 31st of the 10th year. They can take nothing for 9 years and everything in year 10, but the window closes on that 10th year deadline regardless. For a beneficiary who is in a high tax bracket during those 10 years, this creates a compressed tax liability. On an inheritance they may have expected to receive gradually over decades. Some estate planners address this through gradual Roth conversions during the account owner's lifetime. Converting a portion of a traditional IRA to a Roth each year reduces the taxable balance your beneficiary inherits and replaces it with tax-free distributions under the same 10-year withdrawal requirement. None of this is printed on the beneficiary designation form. You have to know to ask about it separately. Now let me give you the 5 mistakes that kill these forms, even when you file them. Because most of the families sitting in probate right now filed something. They just filed it wrong. Mistake 1 is naming your estate as the beneficiary. When some banks cannot get a clear answer from an account holder, the form goes out with the word estate in the beneficiary field. If your POD or TOD names your estate as the beneficiary, the account goes through probate. You completed a form whose only purpose is to prevent probate, and the form sends you directly into probate. Ask the teller to pull your current beneficiary on file right now and read it to you. If the word estate appears anywhere in the beneficiary name field, replace it with a living person's legal name before you leave the branch. Mistake 2 is leaving the contingent field blank. The contingent beneficiary is the person who receives the account if your primary dies before you do. Without a contingent, when the primary predeceases you and you have not updated the form, the account reverts to the estate and goes to probate. You did the work. The form was correctly filed. The protection failed because one line was left empty. Fill in the contingent, always. Mistake 3 is using a first name or nickname. Writing my daughter, or Susie, or the kids, on a beneficiary form creates an ambiguity the bank cannot legally resolve without court intervention. Write the full legal name exactly as it appears on that person's driver's license or passport. Mistake 4 is forgetting to update after a divorce. In most states, a POD or TOD designation is not automatically voided when you divorce. The ex-spouse's name remains on the form until you specifically change it. Your divorce attorney updated your will. Your bank has no idea you divorced, unless you walk in and hand them a new form. The week your divorce is finalized, walk into every financial institution you have a relationship with and update every beneficiary designation you have ever filed, the same week. Mistake 5 is assuming that updating your will updated your bank. People revise their estate plan, pay the attorney, sign the new will, and believe that all of their accounts now reflect the new plan. They do not. A will is a court document. A bank contract is a bank contract. They operate on completely separate systems. A change to one has no effect on the other. The bank does not know your attorney exists. The attorney does not know what is on file at your bank. You are the only person who sits at the intersection of both systems. And you are the only person who can update both. Let me give you one more piece of context before the checklist. Because the state you live in determines exactly how much damage a missing form can do. Most states have what is called a small estate threshold, a dollar ceiling below which a simplified claim procedure applies, without full court administration. In California, that threshold in 2026 is $184,500. Below that amount, a beneficiary can use a simplified sworn affidavit to claim assets. Above it, California's statutory attorney fee schedule applies, running approximately $13,000 in attorney fees alone on a $500,000 estate before any additional court or administrative costs. In Texas, the small estate threshold is $75,000. In Illinois, $100,000. In Florida, $75,000. In New York, $50,000. In Pennsylvania, $50,000. These numbers are the line between a paperwork inconvenience and a full probate proceeding lasting 12 to 20 months, with 3 to 7% of everything you built going to the court system before your family receives a dollar. The 4 forms in this video all serve the same function in relation to those thresholds. They remove assets from your probate estate entirely. A bank account with a POD is not in your probate estate. A brokerage account with a TOD is not in your probate estate. A safe deposit box with a co-renter never has to enter the process at all. A retirement account with a current beneficiary designation transfers completely outside the court. The goal is not to minimize the size of your probate estate. The goal is to make your probate estate zero. Courts in America manage over 1.2 million probate cases every year, according to the National Center for State Courts. Most of those cases involve assets that could have bypassed the court entirely. With a form the bank never mentioned, here is your checklist. Bring this to your bank this week. Walk into the branch. Ask the teller to pull the current beneficiary on file for every account you hold at that institution. Write every name down. Confirm each one is a living person. Confirm each one has a contingent named. Request updated designation forms for any account that is missing a beneficiary or has an outdated name. While you are there, ask about adding a co-renter to your safe deposit box. Bring the person you want to add. Have them sign the rental agreement, and their access is permanent from that point forward. Then call every investment firm and IRA custodian you have a relationship with. Ask separately, what is currently on file as primary and contingent beneficiary on every retirement account? Write down the answers. Request change forms for any account that needs an update. Set a calendar reminder in December of every year to repeat this review. This is not a one-time task. People die, divorces happen, relationships change. The form needs to reflect your life as it is today, not as it was when you opened the account. After tracking the specific failure points in hundreds of documented estate cases, I compiled the exact 4-form checklist, the precise language to use when you walk into each institution, the contingent beneficiary designation language that holds at every major bank and brokerage, and the UTMA custodian wording for naming minor children correctly. That is inside the quiet rules at kevinexplains.shop. Large print. Step by step. Walk in prepared, and you will not leave without the protection in place. $27. If it does not save your family at least $1,000 this year, I will refund it myself. The bank is not stealing from your family when it freezes the account. The bank is reading a contract. Your job, while you still have time, is to make sure the contract on every account you own says exactly who gets the money the second you are gone. 4 forms, all free, 15 minutes each, filed at the right institutions in the right order. That is the difference between your family walking out of the bank with a cashier's check in 48 hours and your family walking out of a courtroom 20 months later, having watched 3 to 7% of everything you built disappear into a system that was never designed to protect them. Do these forms this week, not next month, this week, while the bank is open, while you still hold the pen. I am Kevin. Thanks for watching. Do not forget to check the quiet rules at kevinexplains.shop.